Welcome to Class 8 of the Mr. Cannabis Law coursework. Today we are going to be talking about employment and labor issues within the cannabis space. This is a very hot topic and really is starting to get a lot of media attention and really causing a lot of states to start to change the laws. So this is really an area, if you are an employment attorney, you definitely want to be very familiar with this space, but also really even transactional attorneys, you're going to be drafting different agreements for some of the employees that really does come into play here. So really this does address several different types of attorneys, and very important that you're familiar with this if you're planning to advise any sort of cannabis company or just other companies outside of cannabis that have employees that might be consuming marijuana. So this touches attorneys even outside of the cannabis space. So really what we're going to discuss is a few different things, but the main issue within this space is whether or not an employer can discriminate for an employee when they're consuming cannabis legally, whether it be from a medical or in a recreational state. Remember, these people are consuming it legally from a state perspective, but illegally from a federal perspective. So whether or not employers can fire, hire, or terminate people for testing positive for marijuana is a huge issue. And really the distinction you're gonna see is on-site versus off-site use. This is a very important distinction. So whether the person at issue, the employee at issue, was consuming cannabis on-site, which in most states, no one really is pushing for the employees to be able to use it on-site, or if the employee was using it off-site, which everyone is saying, look, if someone consumes off-site, it's kind of like drinking alcohol. If someone isn't coming into work intoxicated, you shouldn't care whether they consumed marijuana the night before or alcohol the night before, right? They're relatively similar, so why should you care if someone comes into work the next day and they have a positive drug test? What's complicated in the cannabis space is that when you take a drug test, it can't determine whether you are high at that specific time, whereas in the alcohol instance, you could test someone's blood alcohol. So if someone tests that they are testing high in the blood alcohol levels for alcohol, you could say that person was intoxicated at the time. So that causes some very distinct complications. So what we're going to start with is I have on this first slide the Florida constitutional and statutory law relating to marijuana in the workplace. So our Florida Constitution that basically legalized medical marijuana within our state states that nothing in this section shall require any accommodation of any on-site medical use of marijuana in any place of employment. So I bolded those letters because it's very important. It says on-site medical use and it says in any place of employment. So then the Florida statute, which of course is being done pursuant to our Florida Constitution, comes in and says this section does not limit the ability of an employer to establish, continue, or enforce a drug-free workplace program or policy. This section does not require an employer to accommodate the medical use of marijuana in any workplace or any employee working while under the influence of marijuana. So what's important is this language about in the workplace versus not while in the workplace. So moving on to the next slide, what we're going to talk about is the discrimination of these potential employees. So the states have different rules about discriminating against job applicants because of their marijuana use. Even the applicant has a medical marijuana card and they are a medical marijuana patient. So some states have explicitly within their statute protected employees from being discriminated against for medical marijuana use, right? So that's specifically in the statute where employees have protections. And some of those states are Arizona, Arkansas, Connecticut, Delaware, Illinois, Maine, Minnesota, Oklahoma, Pennsylvania, Rhode Island, West Virginia. Those states have actually put it specifically in their statute. Now, there's also been court cases, right? So you have statutory law, but you also have court cases that have also ruled in favor of employees. And, in the coursework, we go through some of those cases. I'm not going to go through all those cases, but the distinction that almost all those cases is making is the difference between on-site versus off-site use. And then there's other states like Florida where they haven't addressed this on-site versus off-site distinction, but I think a very strong argument could be made based on the previous slide that the statute and the Constitution is really only referencing in-state use, and therefore, by negative implication, there should be accommodations for off-site use. No Florida court has actually determined that yet. So let's go to the next slide. And what we're going to have is testing positive for THC at work. So this is really what we're dealing with. So in the Whitmire case, essentially there was a workplace accident and the employer had employees submit to a post-accident urine test. And this is where a lot of this generally comes up, is when there's an accident in the workplace, the employer, by their own procedures, needs to test the employee. And sure enough, the employee tests positive. Now, this happened in Arizona, this Whitmire case, and the Arizona marijuana statute provides that an employer may not discriminate against a person in hiring, terminating, or otherwise based upon a cardholder's positive drug test unless the patient used, possessed, or was impaired by marijuana on the premises of the place of employment or during hours of employment. Once again, their statute made a distinction between on-site versus off-site, and what the court held is that without any evidence that the plaintiffs used, possessed, or was impaired marijuana at work, it is clear that defendant discriminated against the plaintiff. So essentially, what this court is saying, you have to make this distinction. The statute says on-site use, employer could discriminate. Off-site use, you can't discriminate. A drug test comes out. The drug test, once again, for marijuana can't tell whether they were actually high during their work hours, right? So really what this case stands for is that in these types of states where you need to accommodate off-site use, there needs to be some additional evidence beyond just a positive test. There needs to be some additional evidence that that particular employee was actually intoxicated at the time, at the workplace, during working hours. So moving on to the next slide. So really what this is all dealing with is the American with Disability Act. So essentially what the American with Disability Act says is it prohibits employers from discriminating against qualified individuals on the basis of disability, right? So what is a qualified individual? So a qualified individual does not cover any employee or applicant who is currently engaging in illegal use of drugs. Now, this ADA, this is the federal ADA. Now, there's also state ADAs. Most states have their own version of the ADA, but the federal ADA basically says that a qualified individual does not cover any employee or applicant who's currently engaging in illegal use of drugs. This is a federal statute. Marijuana is federally illegal. Therefore, under the federal ADA, what pretty much all of these courts have found is that marijuana is not protected under the federal ADA. Now, we just saw a previous case, but that was under the state's statute. So very important if you're representing someone who has been, fired or terminated for medical marijuana use, that number one, you want to focus on you really don't want to focus on federal ADA law. You want to focus on state law, but you also want to make a distinction between on-site and off-site. So states have their own versions of the ADA, so any employee can seek a remedy under federal ADA, it's state FDA, or both. And so you need to make that strategic decision if you're representing someone. So going on to the next slide. CBD and employment issues. So what's really interesting here is after the 2018 Farm Bill came out, the people testing positive for marijuana had a brand new argument, and I haven't seen a lot of literature written on this. There hasn't been many articles, but I personally, in my practice, believe that there's a very strong argument here. So let me tell you. So the 2018 Farm Bill removes hemp-derived products from Schedule 1 classification under the CSA. So like we discussed, hemp federally legal, marijuana federally illegal. Now THC, the 2018 Farm Bill, explicitly says THC that is derived from hemp, as long as it's 0.3% or less THC, that THC is no longer a Schedule 1 substance, right? So if that THC is no longer a Schedule 1 substance, that means someone can legally consume hemp with THC in it, and it is possible based on someone's metabolism and if they consume enough legal hemp products, that they could potentially test positive for THC. So my new argument isn't just on-site versus off-site, it's also that, well, could you actually prove that the THC test was from cannabis that was marijuana derived versus hemp derived? Now, the way this usually plays out is that the employee tests positive and they may show that they have a medical marijuana card and they end up admitting that it was marijuana use. You then don't have this argument, obviously, right? But if the employee was consuming a legal hemp product, consumed a lot of it, has a metabolism such that it caused a positive THC test, there is an argument that unless they're able to prove that that THC test came from hemp versus marijuana, there shouldn't be anything allowed. So there really hasn't been many cases deciding this. There's been one kind of administrative case in Florida called FDLE versus Roberts. And essentially the court, they didn't directly find conclude the same thing of what I'm arguing right here, but in a way they did. Because what happened, they ruled that the FDA failed to meet its clear and convincing standard to prove that an employee failed to live up to its standards to maintain a good moral character in violation of Florida statute because the employee tested positive for THC, because the FDA failed to prove that the use of the CBD oil was unlawful, right? So CBD and THC, they both could come from marijuana or hemp plant. Marijuana has CBD in it, THC in it. Hemp has CBD and THC in it. If it's coming from marijuana, both of those compounds are illegal. If it's coming from hemp, both those compounds are legal. So essentially what that court was saying is that the FDLE failed to prove that the use of the CBD was unlawful from marijuana versus hemp. So even though this case really kind of centered around CBD and it had some weird language in it, and quite honestly, if you read the opinion, it seems like the drafters of the opinion probably didn't quite understand the cannabis plant as well as they should have, I think it does provide a pretty strong basis that simply testing positive for THC in and of itself doesn't even prove that you necessarily even consumed an illegal substance. So going to the next slide. So how is this handled in Florida? So employers in Florida right now, the Florida statute, I read the language before in our statute, in our constitution, it says in the workplace. It uses language like that. The Constitution says on site, Florida statute says in the workplace. But no court has addressed this. And it's not that the courts haven't addressed this because this issue hasn't come up. I get calls all the time from people who are being terminated because of a positive test. But the reality is most of these are settled outside of court. And so I've had several demand letters where I've outlined my arguments here that the Florida statute and the Florida Constitution explicitly say on site. Therefore, by negative implication, you should, Mr. Employer, have to accommodate for off-site use. It hasn't been determined in Florida courts. I'm really looking forward to the day for the court to actually address that issue. So some other potential causes of action that you should be aware of in these cases is breach of contract, wrongful termination, fraudulent inducement, negligent misrepresentation, violation of the FMLA, or many others. So you really want to be strategic if you're representing someone with these types of cases and make sure you're really bringing a whole plethora of different types of causes of action because they all have different types of arguments within there. So moving on to the next slide, we're going to talk about some other employment issues. And I'm not going to spend a great deal of time on these other employment issues because really discrimination is the main one. But it's important that you could at least get these down from an issue spotting perspective. Discrimination is not the only issue. So you have unemployment benefits. So let's say you get terminated, you test positive, right? You get terminated and you represent this client that got terminated. The first thing they want to do is bring a discrimination case. The next thing they want to do is they want to apply for unemployment benefits. And whether or not they will get unemployment benefits is questionable. So that's another issue. Different states have come out differently on unemployment benefits. So that's something you want to be very, very careful and make sure you kind of do your research. In the coursework, we go through some different cases that have come out differently. The other thing is whether an employee who's tested positive for THC is entitled to workers' compensation when the employee is injured in a job-related accident, right? So if an employee slips and falls, hurts themselves, and he has pain or he broke a bone or whatever it is, he has some qualifying condition, he goes out and he gets his medical marijuana card and he consumes that marijuana, will that be reimbursed under workers' comp? And actually the Florida statute specifically addresses this and says marijuana is defined in this section is not reimbursable under Chapter 440, which is essentially the workers' comp statute. So some states actually do address this. There's also been court cases on it. And then kind of a final issue relating to employment and labor is whether an employee on leave pursuant to the FMLA can use medical marijuana. So if you're on FMLA leave and you use marijuana and then you come back and you get tested positive, whether or not that is okay. And once again, different states have come out differently. The coursework gets into great detail on that stuff. So going on to the next slide is actually we're all done with the material. So really appreciate you joining this lecture. Really important stuff. If you are an employment attorney, be very familiar with this discrimination language and don't just settle. If a state says that they don't need to provide accommodations, the employer doesn't need to provide accommodations, keep reading because it might be referring just to on-site use, not necessarily off-site use. So appreciate you joining me today. That is the end of our coursework. I really appreciate you guys for sticking with me this whole time and best of luck being a cannabis attorney.